Hi guys, so I often get asked by clients, how can I protect myself against non-payments as a service provider? So I thought I would just give you a few tips, clauses to put in your contract with your client that will put you in the best possible position for ensuring that you get paid. So tip number one is you need to know who your client is. So it might seem obvious, but some people literally don't even know who they're dealing with, and you can't sue someone if you don't know who they are. So firstly, get their ID, get their utility bill. If it's a company you're dealing with, you need to get the company registration docs. You need to know who the directors are and get their IDs. You need to have their address, their phone number, their email address. All of that is required so that you can keep in contact with your client throughout the services and also obviously track them down if they don't pay you or they ghost you. Then secondly, you have to have a payments term clause. So all the terms in terms of how you're meant to get paid by the client. Are you going to charge a deposit up front? I would highly suggest this for obvious reasons. It shows you that the client's serious about engaging you as a service provider. They're willing to put their money where their mouth is. If that's really not industry standard and you just, you can't get away with that, then you need to have a very clear payment schedule in the contract. When is payment due? How many days from invoicing date is the payment meant to come through? And then, have a clause that allows you to charge interest for late payments or even a penalty for late payments so that it really incentivizes the client to pay you on time. And then I would also even go further and say, look, if you don't pay us on time, we can actually down tools. If you've got a longer term service provider situation where you've got like a monthly retainer or something like that, or a longer project, then you might want to say, on non-payments by the due date, we can down tools on notice until payment is made, so that you're not in a situation where you're continuously working and then continuously chasing. You actually have the power to stop the project in its tracks until they've made payment. And then if you're dealing with huge sums of money, I would suggest looking at an escrow payment. So, there are escrow services out there where your client can actually pay the money upfront into an escrow. It's held there in trust by this payment service provider until such time as you've completed the service, and then it's released to you. So this provides some form of protection for both you and the client against non-performance, and it shows you that the client does have the funds upfront. Another good clause, if you are dealing with any sort of service which results in intellectual property being created for the client, then I would also include a clause that allows you to retain the ownership in that intellectual property until you are paid in full. And then, disputes do arise, so you have to have a dispute resolution clause in place, which, says how disputes are going to be resolved. Firstly, try the amicable approach between certain high up reps of the companies. And then if that doesn't work, I would suggest arbitration, because mediation's great, but it's not legally binding. So arbitration is a lot cheaper than going to high court, for example, but it is also legally binding, and that's obviously very important. And then you might want to also include a clause that allows for magistrate's court jurisdiction, notwithstanding the amount of money owed. So, there's certain thresholds that force you to go a high court route unless you have those clauses in your contract. And then obviously the mag court is a lot quicker and a lot cheaper than going the high court route, which can cost hundreds of thousands of rand in legal fees. Yes, and then you also want to put a clause in which allows you to apply for summary judgment or even the sequestration or liquidation of your client if they don't pay you. And that clause is known as the liquidated claim clause. So it essentially means you don't have to prove the amount owed. You can simply issue a certificate signed by yourself as a director or your auditor, and that is sufficient proof of the amount that company owes you, for example. And then, of course, it's easy to know what to put into your contract theoretically, but drafting it is a different story. So if you do need help from us in drafting the contract, we can always do a template contract for your business so that you're covered. from both a client perspective or a subcontractor perspective. We're happy to put a service level agreement in place that covers all of these important issues. So just contact me on Taryn@legalninjas.coza, or you can WhatsApp me or phone me on 082 4200 887. Thank you.